CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS Talks.
Talk to me.
CLS
Talk to
Talks.
me.
Real information.
Talk to me.
Real education.
Talk to me. Talk to me. They don't talk to me. They look like they don't talk to me. They back that morning. They don't talk to me. They back that morning. They don't talk to me. They back that morning.
Welcome back, folks, to the CLS Talks. Again, we're sitting in with Lionel Coveney. My name is Des Carty, and you're welcome back, Lionel.
Thanks very much. Good to be here again, Des.
Right, we did say in one of the last sessions that we had that we'd look at the cases that you, or the case you had been involved in relation to the Garda Síochána bringing charges against you, whereby you had mentioned in the last interview that you had other possible defences you could have put forward.
I had, and the reason I had was because I didn't want to take anything for granted. I thought I had a pretty strong case, and as it turned out I did, but I didn't want to take that for granted, and I didn't leave any stone unturned. And to the best of my ability, I researched and learned as much as I could about the law in relation to those charges, and decided, right, if defence 1 doesn't work, at least I have a plan B and a plan C and a plan D.
Okay. Well, what we could do for the listeners' benefit, again, it'll save them having to go over, although we would recommend that you go over and listen to the other interviews, of course, is perhaps you could summarise the case that we covered in parts 1 and part 2.
Okay, well, I was stopped on the side of the road going back about 2 years, and a very unfriendly guard decided to charge me with speaking on a mobile phone while driving and a non-display of tax.
Which you did have. You did actually have a tax on the car.
There was a tax on the car.
Okay.
And I wasn't speaking on the mobile phone. And this really boiled my blood, as I said in the last interviews, because how dare somebody accuse me of something I didn't do and try to attack me then punitively in the court just to, I don't know, benefit himself and his job in some way.
And again, for the listeners' benefit, the case was a criminal case, isn't that correct?
It was a criminal case, yeah, on both counts. So I didn't want to be left with a potential criminal record or to be branded as a criminal, because I'm not, and there's no way I was going to let this one go. So I decided to start working and learning and researching, and we got to a place where I ended up in court about 2 years down the line, and the cases, both charges, were dismissed based on the defence that I used.
With prejudice.
With prejudice, indeed, yeah. So this case is never coming back to haunt me.
Okay, that's good stuff. Again, it's worth noting, listeners, that you need to be checking this stuff out. Anything that is mentioned on these interviews, you need to be researching it for yourselves as well. It's not just a matter of taking what we say for granted, or what Lionel says for granted, or what I say for granted. You need to go and do your own independent research. It will do the world a good anyway, just to cross-reference what has been said here, and you may even find stuff that we haven't covered.
Exactly, and I've noticed, even as I've gone back over these cases, post-case, I've even looked at it and I've thought, well, I could have done that a little bit better, or I could have done this a little bit better, and I wouldn't do it the same now. So hindsight is a great thing, and use what we're talking about. Certainly I still use what we're talking about now to learn further and to learn more, because you never know when something like this will rear its head, or when you will use that information even in seemingly totally unrelated matters.
Correct, okay. Well, to summarise again, you basically had, and you got to the position where the case was dismissed with prejudice, so it couldn't come back and haunt you. So we did mention before in the last interviews that we'd be covering other potential defences. Now, just to summarise again, what was the main defence that you had that got to the position where the judge agreed that the case should be dismissed?
It was to do with the delivery of the fixed charge notice, which, for those who don't know what that is, it's basically the fine when it arrives in the post.
Okay.
And the fine didn't arrive in the post, so I challenged them on that. And it does state in law that you have to be given the opportunity to either pay the fine and admit your guilt, so to speak, or decide then to go to court.
Okay.
So when I had uncovered the bits and pieces in law that stated that this was a requirement, I realised, well, they haven't fulfilled that. So if I haven't been given that opportunity, this case can't proceed. So in essence, that was, in a nutshell, my defence, and it stood up.
So on a technical basis, you did depend on what the actual law stated.
Absolutely, and it didn't even then go into the nitty-gritty as to whether I was on the mobile phone or whether tax was displayed, because I hadn't been given the opportunity, as stated in law, to either admit my guilt or choose to challenge it.
Well, as you might be aware, sometimes we get feedback about cases that we've been involved in directly or indirectly or through feedback, and the arguments there for a lot of people are, well, isn't that a loophole? You've just discovered a loophole, and they will actually go then and fill in the loophole.
Well, I would vehemently disagree with that. It's not a loophole. It is the law. The law is the law. So it's not necessarily that it's a loophole. It's that it's not covered in the law, potentially, which isn't a loophole. It's not a mistake per se. It's just that I've come at it from a different approach to those who maybe wrote that law or those who use that law against others. So I don't see it as a loophole. I see it as my lawful, and in this case, legal right to use that information to defend myself against an attacker.
Okay, well, again, as we suggested, or as I suggested, I should say, there is arguments all the time for this thing being a loophole, and therefore you were lucky, you got off because there was this technical loophole. Now, irrespective of what you've said, I'm not being disingenuous towards what you said. Those are the arguments that others would have. So this is why we're sitting here today, to show that potentially you could have had several other ways of potentially winning that case, either irrespective of what people perceive as being, well, that was a loophole, so to speak. So will we get into one or two of them now?
Let's do it. And it's worth bearing in mind as well that what we're talking about when we speak about the law and acts and statutes, it's a rule book. It's a guide for the judge, in essence, and it is a rule book. So if we're meant to play by the rules, so are they. And what I have done with these defences is uncover as many of the rules as I possibly could, and it can be quite difficult because they don't hand us out these rule books, but I've had a look at the rules and I've said, okay, well, if you're going to make me play by these supposed rules, let's make sure that you have too.
Okay, that's grand. So just to add for the listeners, what we're going to cover here with Lionel today are his other potential defences he could have had, should it have gone on a bit further if the judge hadn't taken cognizance of the fact that the guards essentially had no evidence against you.
That's it.
Ultimately, which is the law. They cannot proceed if they don't have evidence. So again, we had a conversation a little bit earlier, and we kept using the word retrospective or looking backwards in relation to, and as Lionel suggested, if you do a post-mortem on the case, if anybody does on any of their cases, you will learn a little bit more, and don't be afraid to bounce it off others, speak to others about it. Obviously don't get into a conversation with somebody who just doesn't have any knowledge about it, because they'll dismiss what you're saying out of hand. So do try and speak to people who've either had the experience or are prepared to openly look at this and sit down perhaps and do some research on it as well. So retrospectively, we were saying earlier, it might be useful just to point out some of the potential areas whereby you could have potentially, to start with, we discussed one earlier, where you could have won the case potentially beyond the day you did the cross-examination, which was in respect of when the judge was sitting there in front of you and there was another guard in the box taking the place of the guard that was attempting to prosecute you.
Yeah, this was really interesting because in the heat of battle, if you like, in court, it didn't cross my mind to push it in the way that I would now, having discussed it with you, Des. And that was, during the first hearing, there was a replacement guard, a stand-in, because the initial guard, or the prosecuting guard, wasn't available and wasn't present. And I had moved for the court, or in other words, I'd asked for the court to strike out the case based on the fact that there was no evidence. How could there be evidence if this wasn't the guard who had first-hand knowledge of what went on the day?
That's a key word. Now, can you explain what you would comprehend as being first-hand knowledge? That's a key phrase I think the listeners should sort of tune into.
Well, quite simply, he wasn't there. So, as far as I'm concerned, if somebody who wasn't there is standing in front of me giving evidence against me, it's not reliable, it's hearsay. And as we know, hearsay is inadmissible in court as evidence. So, there is a lack of evidence. And people might kind of look at me and say, well, no, hang on a minute, he was told what happened and he's a guard as well. Well, yes, he is a guard, but he's not the guard who's prosecuting me. He wasn't there on the side of the road. He doesn't know beyond any shadow of a doubt what happened on that day. How could he when he simply wasn't there?
Again, the term first-hand knowledge.
First-hand knowledge.
He does not have first-hand information. He doesn't have first-hand knowledge about what happened. How could he, as you suggest?
Exactly.
Okay.
So if he doesn't have first-hand knowledge, he doesn't have cognizance of the events. Therefore, how can he be relied upon to give evidence to the court against me? I didn't see that he could, and I did ask for the case to be struck out. And that was it was kind of shelved as opposed to denied, and I would be far more forceful now, and I would hammer that, because when you move the court to do something, and I now know they have to address that, they have to respond to it in some way, and the judge did kind of leave it and didn't one way or another address it. But I know now you can be forceful and push on it and say, well, look, how are you going to deal with this? We can't proceed until you deal with that.
Well, to codify it into a term that again people need to research for themselves, but you could have sat on a point of law there whereby you inform the court that the man does not have first knowledge, or how could he, or even to ask the question, and then to move the court obviously to strike the case out for want of prosecution, for want of evidence. That point of law on its own, even if laterally they had prosecuted it successfully, would have been enough to bring it into a judicial review or a possible appeal.
Yeah.
So this is something, again, people should be cognizant of or be aware of in certain respects, is that when you're making your points in court, you should be thinking about, well, what if I lose?
Yeah.
What else can I do if potentially I lose this case? So if you're on paper preparing your case correctly, you have all those points of law in relation to what the court did right and what the court did wrong. So you bringing up that point of, if you had brought it up, hypothetically speaking, you then had a point of law in which you could appeal the case if you lost it, and or judicially review the judgment of the court. And
judicial review is certainly something that is well worth looking up, because it's like kryptonite to many of these judges. Absolutely. It's not something, especially in relatively minor district court cases like this, is not something that they want to have rearing its head and embarrassing them among their colleagues potentially. Correct. So that's certainly one to note.
Okay. Again, as we suggest, this is a sort of a two-way conversation we're having here. Obviously, I've discussed a lot of stuff with Lionel. So will we get into some more of the potential defences you could have had?
I think so. There's potentially a very strong defence that I had done a bit of research in the past for a different case on, and had actually used in court before. Okay. As it turned out, successfully. And it's interesting that you've just brought up judicial review and appeal, because in a previous case, a minor case, I had used the defence that I'm about to go through now, and for all intents and purposes, or for the eyes of the public who were watching, I lost the case, despite the fact that I stood on this point of law and would not move. And I was told, no, I lost the case. But when we actually did a bit of research afterwards, it turns out that the order was never perfected. So the case was never followed through on.
Okay, just before we move on again, you keep bringing up stuff that's very interesting, and hopefully to the benefit of the listeners for their interest. You said a perfected order. Can you explain that? What a perfected order is, the process as well?
The order is essentially the judgment of the court. So the judge decides, right, well, I rule against you, and he grants the order, which is what the prosecution have been looking for. Okay. And then there is a perfection process it goes through, which is essentially that it's then the judgment is rubber stamped. Okay, to use layman's terms, and once it's been perfected, well, then the person who's prosecuting can go and seek whatever damages they've been granted, or whatever punitive measures they were looking for, and essentially the law has been passed.
Just I kind of already know the answer to this, but I just we'll have the conversation for the listeners. Who perfects the order?
To the best of my knowledge, it's signed by the judge and then perfected in the court services or the court office, and you can seek a copy then of that order, as I did in this case, in the case that I won. And you can actually look at the order and what's stated and the charges brought against you, and whether you won the case or lost the case, and it's perfected by the judge and the courts. Okay, there is a process that we're cognizant of, and I know you're aware of this. We forgot to mention this, is that in most cases where they're seeking an order, obviously, for a prosecution, and they're successful, what in the normal protocol of things, what will happen is very often the prosecutor, sometimes it's the plaintiff, albeit it could be the solicitor, will draft up the order of the court, and then they hand it in to the court and say, look, sign that. So in most cases, listeners, for what we've established in the past, is that the one that's prosecuting you will draft up what they want to see on the order, and then give it into the court, processes it and perfect it, and then it's issued out, and then it's enforced. And it's very interesting because there's nobody who hasn't been touched at some point by the e-flow scam that's going on. And it's very interesting to note that through my research, I've noticed that the perfected orders are not held by the court service. In those cases, they're actually held by the prosecuting solicitor, which, to the best of my knowledge, or certainly in any of the research I've done, is quite unique. And it does give you an idea of what's going on behind the scenes and how potentially or allegedly the solicitors are colluding or working with the courts.
Now, in relation, like, e-flow are always an interesting topic anyway, I find, most people, because they, as I say, it touches everybody at some stage in their lives, unfortunately. Isn't it strange, I suppose? Now, again, research, you lived on your own independent research, and we've done a little bit ourselves. And from what we can establish, e-flow have a kind of a separate court.
They actually have a physical courtroom dedicated to their cases.
Isn't that amazing?
It truly is amazing. I mean, that speaks volumes in itself.
Okay, so in that respect as well, it follows on that they have a certain set and type of judges as well that they use. So you can imagine the potential there for, I don't know what you might call it, brown enveloping or whatever.
Yeah, some form of potential collusion, I think. Yeah, brown enveloping is a good term.
Let's not infer that, that the courts and the judges and e-flow are all in it together.
Nah, sure. No. I'm sure they're most upstanding. But the point of law that I was potentially preparing to stand on as another defence is the Bill of Rights Act.
What?
Yeah, the Bill of Rights. Now, I'm not talking about the US. We often hear of the Bill of Rights over there. But there is a Bill of Rights Act in this country. Now, it dates back to 1688.
Wow, William of Orange, as they say.
So many people are probably thinking, well, for God's sake, 1688, Lionel, how are you ever going to bring that into court? Surely that has no bearing. Sure, weren't we under the rule of the crown back then, etc., etc.? Well, we were under the rule of the crown. Whether we still are or not is an issue for another day.
Exactly, I was going to say.
We won't go into that. But the Bill of Rights Act of 1688 is a document, much of which has been repealed. So when people are saying, well, it doesn't stand anymore, a lot of it doesn't. However, there are certain parts of it that are still applicable in Irish law. It is essentially the document that members of the Houses of the Oireachtas, TDs and Senators use to this day, that grants them immunity from prosecution for anything that they may say.
Parliamentary privilege.
Parliamentary privilege. So they can basically say what they want in the Dáil or in the Senate, and there are no repercussions or ramifications for saying that.
It sits in the Bill of Rights, then, that law.
Absolutely. Yeah. So we've all heard of parliamentary privilege, and most people acknowledge that it exists. Well, what we're about to talk about also exists and has not been repealed and is still in law in this country. It doesn't matter that the law may have been written in 1688. It's still there to this day.
Still applicable. But it makes sense as well, doesn't it? On reading it, it does actually make sense.
It makes complete sense, and we'll read it now and explain exactly why it makes sense and what it means. So
I'll let you do that.
Okay. The particular line that is of interest is that I'm quoting now, that all grants and promises of fines and forfeitures of particular persons before conviction are illegal and void.
Okay, we need to disseminate that a bit, I think.
So all grants and promises of fines and forfeitures, so fines essentially, that's what we're talking about here, a fine that might arrive in the post, of particular persons, so in this case it's me, before conviction are illegal. So a couple of words stuck out for me there. Okay, fines, yeah, I can relate to that. That applies.
And forfeitures, what are forfeitures?
Forfeitures are
when you give something away,
when you cede something or concede to something.
Okay.
And illegal struck out because I thought, okay, well, could this apply to my case? Could something illegal be done to me as opposed to me being told that what I'm doing is illegal? Yeah. And there's another word, before conviction.
Okay, so I'll have a look at, you'll explain it your way, but in my mind that says, well, you cannot be found guilty of something unless you've been convicted.
Exactly.
That makes sense.
That makes total sense. But then I looked at the process that's used, and there's a presumption of guilt. How is one convicted? Can one be convicted on the side of the road? Not to the best of my knowledge. You're convicted in a court of law. Now,
but aren't there bylaws that allow them to issue fines and stuff like that?
Well, there are bylaws. However, the Bill of Rights supersedes any bylaws.
Correct, yeah. It would be the presiding law over everything
Exactly.
else. Yeah.
So if the bylaw is contradictory to what's stated in the Bill of Rights, well, that bylaw can be discounted.
It's null.
It's absolutely null and void. In the same way as it appears these promises of fines and forfeitures are illegal, null and void, unless you've been convicted.
So, in summary again, I mean, I don't think we can reiterate this too often enough anyway. So, just in your heads, folks, sort of work this out yourselves. When you get a fine, that's actually, they're fining you before you've actually been convicted of a criminal offence.
Yeah. So if you get a fine, ask yourself, have I been convicted in court of this already? The answer is no.
Yeah.
So if that's the case, the Bill of Rights states that that fine is illegal and void.
Clearly, it's in black and white. We're both looking at it.
Yeah, it's in black and white. And again, this might seem too good to be true, or a magic wand. There's no magic wand when it comes to the court system, because you have to aggressively nail your colours to the mast and come up against these guys. But that is what the law states. And just because it's simple doesn't mean that it's not true. In fact, one of the key things that I found in my education to date, and I'm still learning, is to simplify things and not overcomplicate, because a lot of what we're talking about and what we do is actually quite simple and will boil down to a sentence here or a sentence there or a statute, an act, or a part of it. And if you can focus on that and get away from the number of obstacles and the amount of red tape and bureaucracy that's thrown in your way, and the naysayers who say, well, you can't do that, you can't do that, you can't do that, it does become much more simple.
Yeah, it is a simple thing.
Yeah.
It says it there in black and white, and if you stand the ground, which is the law, that you're standing on the law.
Yeah.
By using that and just sticking to that. But as I say, there's a lot of equivocation, prevarication, obscureness and obtuseness as well by the process of the courts and the people within the court to sort of sidestep you or to throw a curveball at you. But if you are able to stick to the law as stated and you can throw it back in their face. Well, anyway, look, let's get on with the actual defence then. So you're suggesting that the Bill of Rights then is a potential defence for you because
it is, because they're using a one-step process as I see it. They're fining you and they're saying, okay, well, either pay the fine or go to court. Now, it should be a two-step process in that you should be brought to court first, and then if you're convicted, you're then issued with the fine.
That makes sense.
Yeah. So they're obviously bypassing layers and layers of paperwork to push these through as quickly as they can, as I see it.
Yeah.
So when using that as a defence, and I have actually used this Bill of Rights as a defence in a previous case, so I have a little bit of experience.
The case. Yeah.
Yeah, it was the aforementioned and much loved EFLO. And I was being brought to court for a number of allegedly unpaid EFLO toll fines and the whole lot, as many people have been. And I decided, right, I'm going to go to court. I'd done a bit of research into the Bill of Rights, and I thought, okay, well, the law states what we've gone through. I'm not having any of this because I haven't been convicted of anything. So therefore, my fines or alleged fines are illegal and void. So I went into court, and it was my first time in court on an EFLO, and my only time, touch wood, in court with EFLO. I was faced by a barrister and prosecuting solicitor and the judge, and the evidence was given by an employee of EFLO or their parent company.
And was that persona or person that was given the evidence, were they in court as well?
They were in court, yeah. Okay. And they got up into the witness
So you had
box.
the judge and three other parties for the other side on one side, and there was you on your own.
Yeah.
Okay.
So that side stated the case, and then the judge reverted to me and said, well, what do you want to plead? And I said, I don't think there's anything to plead to, because I have a point of law that I'd like to bring up on and intend to stand on here today. And I used those terms, stand on here today.
Okay.
And he said, okay. And he was quite amenable to me initially, and the judge said, what is it? So I read out from my notes what we've just talked about, that all grants and promises of fines and forfeitures of particular persons before conviction are illegal and void, as stated in the Bill of Rights Act 1688. Cue consternation on the part of the barrister who was standing just to my right hand side in the court. The solicitor was facing me, as was the judge, and the barrister started spluttering and shouting and coughing and saying that this was disgraceful. How dare I hark back to William of Orange and laws that had no bearing on this courtroom.
Yeah, this is a barrister, you're saying.
This is the barrister who up to then, I had always presumed that they were cool, calm, and collected, and knew the law. And
Yeah, that's the reason I'm sort of, asking the question. Did he know the law, or is...
well, he was certainly aware of the Bill of Rights Act, as was the judge.
Yeah.
And to cut a long story short, there was a lot of toing and froing, and I just kept saying, I'm standing on this point of law. The case can't proceed until we deal with this.
Mm-hmm.
And the long and the short of it is, the barrister pretty much directed the judge to proceed with the case, and the judge said that law doesn't apply in this court here today.
Hang on.
Yeah.
Just hold on for a minute. Right. Now, we've discussed that this law, in terms of the Bill of Rights, that section of the law certainly has not been repealed.
No, it has not been
It's
repealed.
still on the Irish statute books, and people can look it up online. They can go Irish statute book, type in Bill of Rights Act, and they can paraphrase what we've talked about earlier.
Yeah.
And there is a revision of the Bill of Rights called the Statute Law Revision Act 2007.
Mm-hmm.
Now, from your research and my research as well, from what we can both ascertain, it has not been revised, it has not been changed, it has not been revealed.
It hasn't been touched.
Yeah.
And the prosecuting barrister did state at one point that, oh, well, that has been done away with, whereas,
If we go back
whereas
to the
long
judge,
ago.
the judge stated...
Yeah.
What? It stated...
The
I
judge
can't believe what I'm hearing.
stated on the record that law does not apply in my court here today.
That law does not apply in my court
Here today. Yeah, and we had somebody taking notes, and it was written down on the day.
So
and
you
we
have all
still
this
it.
documented?
We have everything documented, and that's what he stated.
Lionel, who was the judge that stated this?
Judge O'Neill, cue internal consternation on my part.
Yeah.
Now, I was very intimidated by the whole process, so obviously I wasn't going to go coughing and spluttering and shouting, but I did say, well, Judge, how can that be the case? The law is the law. It has to apply.
So you did push the law. You
I
were
did.
standing on that point of law, yes?
Now, I wasn't as forceful as I might be today, because I didn't have the same level of confidence, but I did say it, yeah. He got very irate. And he
I'm
said,
not surprised he got irate.
Yeah, he was very annoyed with me at this point. And he said, well, that's what I'm saying now. And I said, well, okay. And I had done a little bit of research into judicial review, and I was prepared for a potential appeal, as we discussed earlier.
Yeah.
And I said, is the option, Judge, of judicial review open to me? At which point, Judge O'Neill said, well, Mr. Coveney, you can judicial review me all you like. I'm not changing my stance. The barrister to my right-hand side addressed the judge and said, this is an absolute disgrace. How dare disrepute be brought upon the court by Mr. Coveney? How dare he threaten to judicial review? Now, I had my wits about me enough to say, well, I haven't threatened to do anything. I've merely asked a question.
Okay.
And the judge has stated that that option is open to me. Is an appeal open to me, Judge? You can appeal anything you want. At which point, 10 seconds later, the case was over. He told me I'd lost the case, and that the prosecution had been granted costs, and they'd been granted whatever it was, number of thousands euro.
So Judge O'Neill willfully just basically put the law to one side.
He ignored the law, and he stated that he was going to ignore the law. It's not applying in his court.
Wow, that is something. I mean, presumably you have a transcript of the proceedings that happened.
Yeah, so word for word, we can state that this is what happened.
Okay, so go on. Let's continue on, because this is very intriguing, actually. And
I was horrified, and I thought I had something to really hang my hat on here in this court. How have I lost this case? And I was really upset. So anyway, myself and my friend who was taking notes, we collected our bags and we started to leave the courtroom, at which point the prosecuting solicitor ran out of the court after me. Now, ran.
Do you mind me asking who the prosecuting solicitor was?
No, I don't mind asking, and I don't mind saying. It's a gentleman by the name of Reborge Pierce from Pierce Fitzgibbon Solicitors.
Or what's the name? You dubbed him as a pet name?
Well,
a friendly name?
I mistakenly referred to him on a phone call in the past as Rhubarb because I had never heard of the name Rhubarb before.
It sounds a bit strange, doesn't it? Rhubarb.
Yeah, and the name kind of stuck, and I've come across quite a number of people who have since used Rhubarb as a pet name for him, but very nice man by all accounts.
It's suggestive of condoms, isn't it?
Well, quite a He ran out of the court after me, and he said, look, he gave it a great go, and he was so patronising, I'll never forget it.
So the prosecuting solicitor on behalf of eFlow,
Yeah.
okay, which makes its way back into being the state anyway, came out. He chased you after the case, and he approached you, and he was, as you suggest, patronising. So what was the essence of what he was talking about? What did he want to talk to you?
Well, I said I gave it a great go, yeah, but I lost, didn't I? And I was not in great
mood,
form at this point. And he said, well,
You weren't in the mood for rhubarb.
no, I wasn't. I said, yeah, I've lost the case. And he said, well, we don't like to see anybody getting a fine as big as yours. It extended to thousands now. And I said, well, clearly you do. You prosecuted me. Mm-hmm. And he said, well, no, I like to be very fair in my dealings. I said, okay, well, is it too late to withdraw the case then? And he said, well, no, I don't mean that. I mean, the order now has been granted and there's nothing I could do about it, even if I wanted to. I said, okay, well, we've nothing to discuss here. And I said, clearly you're not interested in fairness because you wouldn't have prosecuted me, or you would have withdrawn the case the minute I stated the law. Mm-hmm. But no, you proceeded with the case. So he said, well, maybe we can come to some sort of arrangement. And I said, what sort of arrangement? And he said, well, I don't really know yet, but we could reduce the fine, and there are a number of other
the order
cases.
is the order. He got the order for the fine, the whole lot. I mean, that's the order.
He got that. Now, it was stated in court during the case that there were, I saw it as an attempt to besmirch my good reputation and character, but the barrister had mentioned that there were several hundred other passages through the eFlow detectors that I hadn't paid fines on as well. Which may or may not be the case. I don't know. I don't count. And I had, again in the case, I said, well, that's got nothing to do with what's going on here now today. Yeah. It's not relevant because I was being prosecuted for, I don't know, 6 or 7. And as anyone who has got these letters through the door knows, that a fine of €2 or €3 becomes 150 quid odd very, very quickly, out of thin air. So there were all kinds of costs added onto it as well. And he said, well, we could maybe make those other ones go away. And there was another case against me pending for the following January for another couple of thousand.
Okay.
He said, we can make those go away if you just pay the fine. And I said, well, what fine? Well, what the court has asked for, is what he said. And I said, look, I don't want to talk about this. Put it to writing. In writing, you have my address, and I'll think about it. And off I went. And I got a phone call on the way home, which would have been maybe half an hour later, from the same guy.
Rhubarb.
Yes.
Rhubarb, yeah.
Rhubarb. And he kind of reiterated the offer. And I said, look, I'm in no... And I genuinely wasn't. I said, I'm in no state of mind now to retain any of this. I said, I have a terribly bad memory. It has to go in writing. Well, I don't want to put it in writing. I said, that's the only way you can make an offer to me, because I will not remember. I have a terrible memory. And off he went on the phone then. He rang me again the next day.
Really?
Yes, we're at the third time now.
It's almost harassment now.
It almost is. And on the phone, I had calmed down a lot, and I'd collected myself, and I decided, right, I'm going to appeal this, and I'm going to do whatever it is I have to do. I'm not letting this go.
Appeal,
exactly.
Yeah.
Not letting it go, because I was very upset. And I calmed down anyway, and he rings me again, and he said, look, we have to come to some sort of arrangement here. And I said, well, why do we have to? I mean, you got what you wanted. You won. Why do you have to do anything? Why are you pursuing me for this? What's going on? And he said, well, we're very fair, and we're concerned that you may not be able to pay. And I said, well, you don't know what my earning capacity is or isn't. How do you know that? He said, well, are you such and such a thing? And he stated... He
was sussing you about. That's what he was doing.
And he asked me, was my profession a certain thing, my day job, so to speak.
Okay.
And
so he'd done a bit of research.
He had done a bit of research, and he was right. I mean, he had correctly identified my day job.
Yeah. And
I said, well, it's none of your business. And I said, is your day job ripping people off? Which didn't go down well at all. And he said, well, look, no, we both know that it's not. And the phone call went on and on. I'm trying to remember it here on the go, but words to the effect that, well, you're clearly very capable and you've clearly done a bit of research, and that's to your credit. And I said, don't dare patronise me on the phone. I said, if you have an offer to make, as I've said to you twice before, once in person, once on the phone, put it in writing. And he said, well, it will be off the record. And I said, well, it won't. You'll be putting it in writing. And he said, well, it'll be without prejudice. And we've
that word again,
we've
yeah,
addressed
yeah.
that word, prejudice. So if something is without prejudice, it is essentially off the record and can't be brought into court. A point
Yeah.
to note there is you can simply quote that letter with prejudice in your response, and you can get it on the
Yeah,
record
back
that
in,
way.
yeah.
But so I said, whatever, just put it in writing if you've something to say.
For flip's sake.
Yeah, pretty much. And again, off I went about my business, and I did receive in writing an offer of sorts. He went back on a lot of what he said, and he said the other cases would go away or whatever. He said no, they weren't going to pursue costs. They were willing to waive costs and just look for the fine, and that was it. So I wrote back and I said, this is ridiculous. I said, this isn't worth the paper it's written on. Go away. I'll now be appealing,
I'll see you again.
and I'll see you
Yeah.
again. And the next step then, Des, was to try and find out what exactly the order stated. So I requested a copy of the order from the courts.
I vaguely remember speaking to you going back some time ago.
And I was really concerned at this point. I thought this was a miscarriage of justice.
Yes.
Yeah. And the court said, no, you'll have to revert back to the solicitor, because, and this is how we gained that nugget of knowledge. You revert back to the solicitor because they hold all the orders pertaining to e-flow cases. So I took grand. So I wrote to the solicitor, said, I want a copy of the order.
Oh, you wrote directly to...
I wrote to Pierce Fitzgibbon then.
Pierce Fitzgibbon, yeah.
I said, I want a copy
Rhubarb.
Rhubarb. I said, I want a copy of the order. An order wasn't forthcoming. And
Now, do you mind, can you recall how long it was then between when they got the order the day in court and you writing? What was the time frame?
it wasn't long. It was maybe a week, 10 days, something like that.
Fair enough.
It certainly wasn't.
But an order like that wouldn't be difficult to draft up and get ready and process anyway. And in most cases, the orders for those types of things are already pre-drafted.
Oh, they're templated, and they just
Yeah.
insert the details, as far as I can see. So there appeared to be a missing order, and I needed that order so that I could appeal.
Correct.
And I stated that I needed that order so that I could appeal. The order wasn't forthcoming, and I was told I wasn't entitled to a copy of the order.
Who told you that you weren't entitled to a copy of the order?
The solicitor said I wasn't entitled to it. The court service had said I was entitled to a copy of it, and that it was held by the solicitor. The solicitor said that I wasn't. So I thought, right,
interesting.
something's going on here.
So either the court are lying to you or the solicitors are
Or the
lying.
solicitor.
And there's no other way to put it, because a lie is a lie. One has lied and one has told the truth.
Yeah. So I reverted back to the court service, and they can be very tricky to deal with, but I eventually got a response. And what I wanted to know was, would they know when an order has been perfected or not? Would they have access on their records to that information? They said, yeah, they would. And I said, okay, well, here's the case. Has this order been perfected? What's going on here? Because we can't seem to track it down. The long and the short of it, Des, is that the order was never perfected. And I wrote then to the solicitor demanding, not asking for, but demanding, one of these notice demands, a copy of the perfected order so that I could prepare
Let's put a line across that just to summarise it for everybody. You went to court with e-flow. E-flow brought you to court. Rhubarb brought you there. He was a prosecuting solicitor. They got the order from the court. The judge basically said, well, we'll ignore the law for today and we'll give them the order irrespective.
Yeah.
Then their process now is to perfect the order, bring it in, to have the judge sign it. As we've seen orders that were put in front of us today as well, the judges stamp it, sign it, so on and so forth. Then the order is ready for the solicitor to take up and follow you on it, or the other party.
Yeah.
So that process of the order being perfected and lodged to the court for the judge's signature and to be codified and brought back into force just did not happen.
It did not happen. So while it appeared that I had lost that case, I started to come around and think, well, if the order hasn't been perfected, I haven't lost the case. I may not have won it, but they have to perfect that order for it to stand in law.
Absolutely. They have nothing then to follow you with if they don't have the order. There is nothing in law they can follow you with. Now, what we'll do is, Lionel, we'll take a quick break and we'll come back with a part 2 of this because we've extended our time.
We have.
I think the listeners then can tune in to part 2 when it's ready. Is that
perfect?
Okay?
I'll be looking forward.
Thanks again for tuning in, and we'll see you in part 2 of this part.
CLS Talks.